If you or your child are the victim of a dog bite in Detroit, contact the dog bite attorneys at Strobel Law Firm PC today for your free initial consultation. Our personal injury attorneys have experience working with dog bite victims throughout the state of Michigan, and we care about your well-being. We can put our proven techniques to work, including investigating a dog bite case by reviewing licenses, vaccination, and medical records. We can also interview eyewitnesses who can refute commonly asserted defenses that the dog bite was somehow provoked or that the harm was the result of the victim's own negligence. There are approximately 4.7 million dog bite victims every year in the United States, with nearly 800,000 requiring medical treatment, according to national studies and surveys. Last year alone, 33 people were killed as the result of a dog bite or attack, including 18 children. Being attacked by a dog can be a painful and traumatic event. However, if you or a loved one has been the victim of a dog bite, you can seek legal remedies through Michigan's Dog Bite Statute or common law claims. Michigan's Dog Bite Statute provides the following. If a dog bites a person without provocation while the person is on public property or lawfully on private property, including the property of the owner of the dog, then the owner of the dog shall be liable for any damages suffered by the person bitten, regardless of the former viciousness of the dog, or the owner's knowledge of such viciousness. In other words, unless you somehow provoked a dog or incited it to attack you, the dog's owner faces absolute liability for your damages, including your pain and suffering, medical expenses, like emergency room treatment, stitches, shots, x-rays, and any rehabilitation, and lost wages. It does not matter whether the owner knew of the dog's viciousness or whether the owner's carelessness caused the dog bite. In addition to the dog bite statute, Michigan law recognizes common law claims for your damages if you've been attacked by a dog or any other domestic animal, such as a cat. These claims include strict liability. A dog owner can be held strictly liable for damage done by a dog if he or she knows or has reason to know of the dog's abnormal dangerous propensities and the harm that results from that vicious or aggressive trait of the dog. You don't need to show that the dog has previously attacked people, but instead, that the owner knew the dog had a tendency to attack humans or other animals. You would need to show that the dog has an ill temper, aggressive behavior, and a tendency to become agitated and hostile. However, keep in mind that mere barking or growling at humans is considered normal canine behavior and may not support a claim. Negligence. Michigan law also recognizes that a dog owner who does not have knowledge of the animal's abnormal dangerous propensities can still be held liable for negligently failing to restrain the dog or prevent harm by it. For instance, the owner can be held liable for failing to put the dog on a leash or in a cage or kennel area. Trespass. If a person's dog goes on your property without your permission, a claim of trespass can be filed. This type of claim might be highly relevant if the dog has come into your yard and attacked a child or one of your own pets. Battery. In some cases, a dog owner might have intentionally tried to harm you with the dog, using the dog essentially as a weapon. Get Strobel Law on your side today and get the legal attention and dedication your claim deserves.